Hello, everybody. So good to see you tonight. Hello, Nana Laura. Hello, C-Rex, my love. Hello, Ginny. I am so happy to be here, and so is Bandit. She sure is turning out to be the perfect paw pet. I can't tell you how much I love this kitty cat. She's so wonderful. They probably aren't expecting the earlier time, but I'm gonna try to make this my usual time. It's gonna be an attempt. I'm two for two now, 2 for 2. So yeah, it was actually quite a struggle because I had to watch a lot of the dockets to put all the pieces together because so we have a couple of updates tonight. We're going to get an update on the man who had to put $800 into the registry. So that's going to be the first one. The second one is going to be the gentleman who had the restraining order problem. And oh, look, I am now a cat toy. Instant cat toy. I got these little ties on the sleeves, and Bandit figured out how to untie the ties on the sleeve. She's so perfect. Hello, Mike. Oh my gosh, so good to see you, Mike. No. Okay, so, and then after these updates, we have I believe it's two brand new ones that are full hearings from the previous weeks and now current. So I had to kind of flip-flop and zigzag around a little bit to make them all run in order together. Hopefully my editing skills worked. Let's all just say that little mini, just a little one, because yeah, we know it's retrograde and my editing. Hello, Dana M. All right, we're gonna get right into it. You are just having a ball over there. Oh my gosh. She's like, best dress ever. Hello, Finna7. Oh my gosh, I've missed you. Hello, Eileen E. Carlin. Oh my gosh, you guys are the best. I love you all. I should also say, real quick, every paw pet is in this video. This here is our beautiful Tiny Kitten Esquire. Hello, Patrick B.
So first, Sunny Meadows Mobile Home Park v. Terry Galloway, Barbara and Elijah Melvin, and Amanda Phillips.
So we have a procedural issue before we commence. Here's my issue. This is a case where a writ was issued. Subsequent to the writ, Mr. Kiernan filed a motion for stay, does not serve that on me, gets the stay, serves the stay along with an email stating, here are all these things I'm serving on you, none of which are attached. Only attaches the order for stay. This is provided yesterday afternoon. I reached out to their office this morning. their office provides midway through the docket. Oh, well, here's some of the things that we said were attached but weren't, acknowledging they didn't actually serve them. And what's then subsequently provided still does not include the motion for the stay. So as we stand here, I still have not been served with the motion for stay, which is a significant problem when we're going to go to the court ex parte and ask for relief, and there's counsel involved to not provide notice to counsel. If you're going to file a motion ex parte, so be it. You have to provide service, and to not have provided service by the time docket starts, frankly, is just not excusable. Because there's no way for me to proceed forward. I haven't seen it. Can't tell you what's in it. So there's no way for me to defend my client. So what I'm asking to do is to set the matter over 1 week. Mr. Kiernan's office needs to serve the motion for stay on my office. And then I'm also asking for terms, and those terms should be paid. We're only here based on that motion, the ex parte motion for stay. There just isn't any reason why it wasn't served on my office.
I would just respond that I filed the stay under RCW 5918-410-4, which allows me to file it ex parte with an email to her, which states that. But this is kind of irrelevant, quite frankly, the motion, Your Honor. The only thing that is really relevant here is 410-2, which doesn't require me to do a motion. My client, within 5 court days of the entry of the judgment, so within 5 court days of when he was evicted, put all of the money into the court registry, Your Honor. If you look at 410-2, it says before entry of the judgment or until 5 days after the court has expired.
Kiernan, when did you serve these on me?
It doesn't matter. There's no motion.
Hold on 1 second. So let me just back up here. I don't have, so hold on, I'll let you both speak, I promise. But I'll tell you what I do and what I don't have. I don't have, and I assume it was done yesterday, so it wouldn't be in the system yet, but I don't have the ex parte stay request. I don't have the order staying. What I did receive after docket started was a motion to reinstate tenancy, indicating that the $3,000, which allegedly exceeds the rent owed, court costs, and late fee, I have that motion in front of me, and I'll be honest, I'm reading it as you're speaking, Mr. Kiernan. Again, I didn't have this before docket. I don't know if Ms. Baldwin has this.
And can I just briefly explain the posture of this, because it is a little bit confusing, Your Honor.
Okay.
We have within 5 days from when the court issues the judgment to put all the money into the court registry. On Tuesday, we did this with all the money, and I told Miss Baldwin, and we provided her with receipts that showed that we paid all of this money into the court registry, Your Honor. At that point, I thought the landlord would take it on themselves to reinstate the tenancy, because if you look at the language of 410-2, there's no motion. It just says as soon as that money is in the court registry, the tenancy is reinstated. It's mandatory. There's no judgment on your end. There's no I need to file a motion. It just says before entry of the judgment may pay into the court the amount of rent due, any court costs incurred at the time of payments, and late fees, in which the judgment and enter shall be satisfied and the tenant restored to his or her tenancy. So once we put that money into the court registry, the tenancy was restored. We don't need to do a motion. We don't need to do anything. And it's undisputed that that money is in the court registry, Your Honor. Now, this writ was executed on Friday or on Thursday. My client is currently not able to go into his home, which he has been reinstated in, Your Honor. There is no dispute that this money, $3,000, was into the court registry. Now, we might be able to say, quite frankly, it's really a question of how much money my client's getting back at this point. But it's undisputed that my client put more than enough money into the court registry. There doesn't need to be a motion. There doesn't need to be anything. It is an execution of him putting the money into the registry, Your Honor. And opposing party had full knowledge that this money was in the registry, Your Honor. I sent them an email which stated that. So I'd ask you to sign an order today which allows my client to return to his home.
Ms. Baldwin, go ahead.
Boy, howdy, that's a lot. Mr. Kieran says it's undisputed. Boy, wouldn't I love to serve somebody as docket is proceeding and then say, with no ability for the other side to respond, well, it's undisputed. It's undisputed because my client hadn't even had a chance to look at these documents because docket is currently going. They don't even deny that they didn't serve me with anything other than the order late yesterday, and then served me with the other documents as docket was proceeding today, and only at my prompting that their certificate of service was incorrect. So counsel stating there's no dispute. There's no dispute because I haven't had an opportunity to. And that's the whole point. It is wildly law by ambush. And so much so that you're doing it on docket as docket is proceeding. I'd love to serve Mr. Kiernan with documents as docket is proceeding and then just say, well, it's undisputed. His client doesn't dispute that he owes rent. Mr. Kiernan's going to demand 2 weeks. So it's offensive. It's offensive that Mr. Kiernan thinks it's appropriate to not serve me and that that's fine. It's not fine under the law. The argument that, oh, it's just automatically instated. No, there is a court order to execute and to remove them from the property. Only if they can show and have a hearing that says, oh, we've paid and there's a dispute. And Mr. Kiernan's wrong. It says they have to pay the full amount in rent that is due and owing at the time, attorney fees. They also have to pay certain amounts just to redeem the tenancy. There's sort of like a fine that's built into the statute. Mr. Kiernan just sort of wants to sweep that all under the rug and ignore that there's all these additional things that are part of getting a tenancy reinstated. So where we are now is Mr. Kiernan's clients at the 11th hour got a stay. So they haven't been reinstated. There's no order that reinstates them. What they have is a stay on the execution of a judgment. So that's where we are procedurally. Where we need to go is that Mr. Kiernan needs to serve any documents he's filed with the court on me. And we're still in a position where he has not done so. And then have an actual opportunity to have a hearing where both sides can be heard. This is not a one-sided deal where only the tenants get to file things and be heard. This is an adversarial process where both sides get to be heard and both sides get to have their evidence before the court. And Mr. Kiernan's arguments to the contrary are just simply contrary to justice and contrary to the law. So in this case, my requests for terms are appropriate given the lack of service and given the fact that I've had to sit through this docket for this hearing due to the lack of service. I'm asking to set over 1 week, require them to serve anything that they haven't at this point served on me, which includes at a minimum their motion for stay. And then I can respond appropriately and we can have an actual hearing next week.
And Your Honor, I would just like to note under RCW 410 or 48, RCW 5918-410-4, I'm able to file these ex parte notices with emailing, serving her, letting her know that I did that. I'd like you to note that in nowhere in any of the defendants or the plaintiff's argument did they state that I did not let them know within 3 court days or within 5 court days that all of the money was in the registry, Your Honor. We sent them a receipt from the court registry. Quite frankly, normally when this happens, Your Honor, the defendants the plaintiffs take it on themselves to stay the order because they know that they have all the money. They're trying to muck it up by saying there's court fees and all of these other things. No court fee or no attorney's fees were awarded. We paid in excess of the amount by quite a significant amount. When we were here 2 weeks ago, Your Honor, they were saying that my client owed $1,300. There was already $800 in the court registry. My client has since deposited another $2,200 into the court registry. There's really no way that we can make this, that we can figure this out that doesn't have my client covering all the bases. So once they covered all the bases, if you look at this, there's nothing mandatory. I mean, this is all. It says once if you read the entire provision on number 2, once my client puts that money into the court registry, they have reinstated the tenancy, Your Honor.
Now, I would just like to remind you that at the last hearing that we watched, which I will put a link in the description that takes you to it, but in the last hearing that we watched, the property owners do not want to rent to these people anymore. They don't want them as tenants. And the writ was ordered for the tenants to vacate. And this defense attorney went into, super sleazy slimeball mode and had them put the rest of that money into the registry, which there's still no definitive amount of what is owed. And then he filed a motion for a stay of eviction so that they couldn't be kicked out of the property. The landlord doesn't want them. They have not paid rent in over a year. They keep having outside government agencies pay for them. And the landlords are quite frankly sick of it, because the only time that they do pay is when they're taken to court. And so it's not a profitable service for the landlord to have to continue to pay the attorney's fees only to be able to get the rent that's due. And for the rent to then be being paid by outside government services, because these people are just as upstanding as this attorney. Now, I'll tell you, he's got some ability as a defense attorney. I mean, minus the constant itchy scratchiness and the look like a used car salesman / video game aficionado. But I mean, he can think of the lowest ways out of any situation, which, that's what a defense attorney can do.
So I would like my client to be able to go back into his home.
But here's my question, because what triggers the restoration of tenancy is pay into the court or the landlord the amount of rent due, any court costs incurred at time of payment, late fees if such fees are due under the lease and do not exceed $75 in total, and attorney fees if awarded. So what is that amount? I guess that's what I'm missing. I have heard, Mr. Kiernan, you say, of course, it's more than what's owed, but I don't have that amount.
So they stated as of last time we were in court, it was $1,300, Your Honor. My client,
and contrary to the pleading,
or $1,600, I believe, and that was in the declaration that they filed. My client had $800 in the court registry, and then so my client technically only had to file, a smaller amount than what they did file. December's rent has passed, so even if we include December's rent payment of $800, he's still well in excess of the amount that he needed to pay, Your Honor.
So what is the amount he needed to pay?
I can do some. I just want to get you the correct numbers.
Yeah.
Should have been done earlier.
Ms. Baldwin, what's your client's position about what's owed?
So it puts me again in a almost impossible position, because Mr. Kiernan plays this game of, I'll serve you as docket is going, respond on the fly, and then I win. And that's why it's not fair. This is law by ambush. And that's why this is not a lawful process to do it this way, for Mr. Kiernan to sort of play this game this way. So so I can tell the court that the last pleadings showed only through November that he owed 1,800, and I'll just say 60. It was 59 and change. Plus he owes December's rent. Plus he owes court costs. Plus he owes the statutory amount for redeeming the tenancy. And I would argue that the court never addressed attorney fees. So the court also needs to address attorney fees, which at this point are substantial. We've had multiple hearings on this case. That does take us to a place. And again, the court has to recall, this is a case where the tenant has not paid for essentially a year. This is a tenant where previously redeemed the tenancy in the middle of the year. So there's a tacking under the statute that every time you redeem, that you have to pay more essentially each time. So again, these are things that I'm going to have to sit and do the math to see whether or not this actually gets us to a place of whether he's put enough, because I think it's a legitimate question on whether or not he's put enough. it's odd to me that Mr. Kiernan is saying my client can return to the home. They got their stay. They got their stay. So his client isn't out of the home. They got their stay. So, and I'm not saying that that stay is not enforced for the following week. At this point, the stay is in place, and I haven't been served documents for me to be able to address it.
What is the
I
emergency?
guess my major concern was the
hold on one
client
sec.
being allowed in the house. So
Just-
if there's no dispute about that, I'm okay with as much time as necessary, quite frankly.
Because again, it's not in my system, probably because it happened yesterday. What's the wording of the terms of the emergency stay? What is it?
I think it's just said it's just stayed.
Yeah, it's just the state of the execution of the writ, which technically the writ's already been executed, Your Honor.
But does it say until the next hearing? I guess my question is whether that emergency stay expires today.
Well, I guess then so that's a factual question. Mr. Kiernan, was this executed prior to the stay?
It was executed prior to the stay, but I'm saying that he reinstated prior to that.
So that's a really significant financial question, or factual question, because the statute says that they can be reinstated and redeem the tenancy, but only until the execution. So frankly, the time, like I only have a conformed copy. I don't have like the clocked copy on when this was clocked. And frankly, the clock matters on this one. Because if the sheriff's office removed them from the property prior to the stay, then that's probably dispositive in this case, because they
and our issue would be that they reinstated prior to the execution because they put the money into the court registry prior to the execution, Your Honor. And just to let you know, so my numbers are total, including December rent. He owes $2,842, and he's put $3,000 into the court registry. And I would just like to note, at the time that my client knew what he needed to do to redeem, attorney's fees had not been awarded, Your Honor.
So
We understand. So here's what I'm going to do. I think that this strikes a balance. I think this is a very unique case procedurally, factually. There are a lot of moving parts here. And again, I wish I had the stay language in front of me. But what I'm going to do in both law and equity that I believe is fair, I'm going to sign a bench order that continues the motion to restore tenancy, or to reinstate, motion to reinstate tenancy under subsection 2 to next Friday, December 13th at 9 a.m. I am going to include in my bench order that given a threshold showing of payment into the court registry, that might cover court costs or all of the past due rent, court costs, et cetera. And again, might, because we haven't held a hearing on it, that the starting right now at 10 a.m. on December 6th, that the tenants are to be allowed back into possession of the rental property through the date of our next hearing, when a final decision will be made.
Thank you. That works for me, Your Honor.
Yeah, I'm just trying to think through the problems.
Yeah.
Because they've already been evicted from the sheriff.
Mm-hmm.
But my concern. I mean,
I know.
effectively, if the court
Mm-hmm.
if the court sides with me, it doubles my client's costs on the essentially on the sheriff's side, because then they won't leave voluntarily. We'll have to have the sheriff come out again, and have to re-execute essentially a new writ.
And and I understand that. I think the issue that I'm having, and again, I don't have it in front of me, is that my understanding is that a motion to stay execution of the writ was filed, correct me if I'm wrong, but I think the ex parte motion for stay was filed before there was execution of the writ. It wasn't signed until after, but it likely does stay execution of the writ that may or may not have applied to retroactively. I don't know. I don't know what the judge signed. I have no way to know. But I think what I'm signing today in under the RCW is to continue the motion to reinstate tenancy so that we can do the fact finding to see if these things have been paid. But I think in equity, given everything I have heard today and my understanding of the timing of events, I think it is equitable for the tenants to be allowed back into the property for this week pending that hearing. It does appear, just again, Ms. Baldwin has not had a chance to run the numbers, and I completely understand that argument. Just based on the numbers we have here today, there's been at least a threshold showing that he has paid amounts into the court registry that might cover those full costs. So that is why I'm granting the week. We'll resume next Friday with whether this truly is a reinstatement of tenancy or not.
Okay. very
Now,
good.
I understand there's some weird factual things. How do you unring a bell that's been rung? I know that's come up before, but my hope is with my bench order that at least for the next week, they are allowed back into possession of the property.
Thank you, Your Honor.
I'd ask that the court previously ordered this and it should continue that Mr. Galloway and whoever has paid into the court registry cannot remove funds from the registry, that those funds are held until court order.
Yeah, I think that's reasonable. If he did
Okay.
remove them, I think he would be evicted because they wouldn't be paid to the landlord.
Well,
No.
it's gamesmanship that he could be then removed and then play the game of, but now I'll pull my funds back. So
Okay. I will include that. The
My
tenant.
client wants to remain in the home, so part of that is keeping that payment, Your Honor.
Okay, so pending final resolution, tenant is not to remove funds previously deposited from the court registry. Okay. Okay, thank you both. We'll see you back next Friday.
You know darn well those tenants are going to end up as squatters. Speaking of squatting, anyone else think that Jeff takes the law books into the crapper with him to find the crappiest defenses that he can for his clients? That's where I'm at with it. Yep, that was Earl. This is Earl's picture. I guess he was making his presentation with his picture up. Yes, Ava, we know.
And then any other ones, Mr. Kiernan?
Oh, I guess maybe the carer matter with Miss Winkles. I think we're trying to strike that. I think they're going to pursue another action, but I think my client is going to be out at the end of the day.
Let's see. I know Ms. Winkles also has a Wakayakum docket, but Ms. Winkles, are you with us? Okay.
Let's hold off on that.
Oh yeah, I'll call that one back. She did send a message about a separate docket.
I am, Your Honor. Can you hear me?
Oh, there you are. Did you want to? Oh, Ms. Winkles, did you want to handle your matter or wait?
My apologies. I'm in two dockets at the same time. If we could handle my matter now, that would be wonderful.
Okay, this is number 7 on the docket, 242-010-1108, Myers v. Carer. How are the parties asking to proceed?
Your Honor, I'm asking to go ahead and proceed with the unlawful detainer and ask for a writ. There was a domestic violence, there was an anti-harassment order already entered, and even though it was entered by default, there were findings made. Therefore, I believe it fulfills the statute, and so I'd ask for the writ to be entered today.
Mr. Kiernan, it's a little bit different than how you thought you might be proceeding today. So
Certainly different. Well, I believe last week we said that there was a material issue of fact here, at least as to if there was, a situation. So I'd ask that you set the matter to trial then, Your Honor.
And because there's no question of fact, because findings have already been made by a judicial officer, I'd ask that the writ be entered.
I just don't think a default judgment would be, a correct way, especially when we already had findings in the record from my client. I just don't think that would be appropriate, Your Honor.
And so just so I am clear, the idea is that because the protection order was entered and there were findings made in that precludes any sort of disputed factual issue in this case. Is that what I'm understanding the argument to be?
Yes, because there were findings as to harassment. He was given a notice as to harassment. And that was the basis for the 60-day notice that my client gave was harassment.
So my only concern with that is that, as both of you know, in civil protection order cases, the rules of evidence are relaxed. So oftentimes things that would be otherwise inadmissible in a normal civil case can be admitted and decided upon by a judge. So I do want to be careful about what potentially, I guess I think it's a little bit of apples to oranges. So I guess Ms. Winkles, you can respond to that.
Yes, Your Honor. When there are findings as to harassment, essentially, even though other evidence comes in, the civil protection order essentially excludes this person anyway from being there for a year on that property. Furthermore, under the Unlawful Detainer Act, there is a caveat that if the owner is unable to enjoy his property, and if the tenant is harassing them, that you can give a 60-day notice and the person needs to move. That 60 days has come and gone. He has not moved. He was provided notice. There is harassment. There are findings as to harassment. Harassment is a low threshold anyway. It's not domestic violence. It's not anything of that nature. So in this case, Your Honor, I believe it is justified. He was given proper notice. There's nothing like he's moving out the next day. So we'd ask for the writ to be entered.
Mr. Kiernan.
Yeah, I mean, I'd first off just like to respond. I didn't even know that there was a protection order that was issued until just 5 seconds ago. So I just like notice and be able to address that with my client if we're going to be through this. But quite frankly, I think this is a separate matter. This involves, the RLTA, which has very different standards than a protection. I think we've created a material issue of fact. My client is vigorously, saying that this didn't happen. I think we might be in a slightly different situation, Your Honor, if this wasn't just a default judgment. But my client essentially never really had a chance to vindicate the facts of this matter. And when he was represented, had an attorney, we did strongly dispute these matters. And I think we've created a factual problem, Your Honor.
Yeah, I mean, I know when we were here last, essentially, and I'll be honest, I don't see and I'm going to look through any unscanned documents. I didn't see that the protection order was entered into evidence here. Yeah, I don't have anything new. So since we were last here, so let me back up to where I know we were on the 22nd. At that time, we did discuss material issues of fact. My ruling on the 22nd was I was requesting briefing on the issues presented. I found there was a material issue of fact on the underlying issues and that it should be set for trial. In lieu of getting you all set at trial, the parties discussed continuing it 2 weeks for additional briefing. I have not received additional briefing. So the options for the parties, again, noting that the civil protection order is not in evidence here. So I can't simply, because it's the same court, I can't pull in a protection order that was done on a different docket into evidence in this case. It is actually not in front of me. So
he did cite the civil protection order in his last reply pleading. He actually cited that he was going to that docket, that obviously the outcome of that was not entered, but the docket is.
So it's not right. So it's not in evidence here. So I can't simply just go look at another docket to take those findings and put it into here. So what I can do are two options. I previously 2 weeks ago found that there were disputed issues of fact. Nothing new has been presented to me, but in terms of admissible evidence. So I can allow you all additional time to submit that briefing and we can hold a further hearing, or I can put you on trial assignment and you can set this for trial.
Your Honor, I'd ask to strike. I tried to actually strike this a week ago, but I guess because it was a show cause, the clerk wanted me to come anyway. And then we obviously the DVP or the anti-harassment was granted. So then I obviously thought, okay. So I think if we can just strike this, my intention is still to file under the pay or vacate. And I think that's what we're going to do.
Okay. Mr. Kiernan, since they are the moving party and the request now is to strike, I assume no objection.
No objection, Your Honor.
Okay, we'll go ahead and just strike number 7. Thank you both.
Thank
Okay.
Yeah, it seemed that way.
And then that takes me to number 8, 24-2-010-1508 Cornerstone Residential, Westgate Terrace. V. Christina, is it Chappelle or Chappelle?
I believe it's Chappelle, but I'm not
One of the
100%
ways.
sure on that, Your Honor.
And I don't know if we have, I have someone logged in as Chells. I don't know if that's someone with this case because I don't think I have anything else left.
Everybody, buckle up, because this is 2 hearings, 2 weeks apart, and there's a reason that I hunted the hearing down.
If you're logged in as Chells, can you let the court know who you are?
I doubt my client is going, or
Okay, they logged out. Okay. All right. And so, Mr. Wagner, you're here on behalf of plaintiffs.
Yes, Your Honor.
Okay. And then I have Josh Ramsey on. Who are you with?
He is the plaintiff.
Okay. Thank you. And then Mr. Kiernan's here on behalf of the tenant. So are we proceeding on the show cause motion today?
We are, Your Honor. Although I'd first like to just ask a couple things. If the tenant's not here, I'd like to first move for a default. The tenants are required under 380 and 37, 5918 380 and 5918 370 to appear. The unlawful detainer statutes are clear in that.
and Your Honor, I'm appearing on behalf of my client.
Yeah, that I am going to deny that request. There was an answer in motion filed by counsel of record, so we will go ahead and move forward.
Okay, thank you, Your Honor. If I may ask one more thing here. Opposing counsel just yesterday provided an amended motion to dismiss. This is the second time I've gotten a motion to dismiss 1 day before the hearing. I'd like to move to strike this amended motion as untimely.
He really likes those last minute motions that make it so that the other side can't do anything about it.
It provided several new defenses. The statute 5918-380 is clear in the first sentence that at the time and place fixed for the hearing, that's when the defendant is to provide defenses. The hearing was scheduled for October 25th, was then continued to November 8th, and then it was continued again to November 22nd. It does not allow, the statute does not allow for the tenants or tenant attorneys to just continually compile and come up with new motions to dismiss, new defenses ad nauseum. So I'd like to move to strike that amended motion to dismiss.
Mr.
And I would just say that the statute allows me to answer up until the time of the hearing, Your Honor. We're at the hearing right now. And quite frankly, my 2 additional offenses go to jurisdiction, Your Honor, which means that you do not have the ability to even issue the writ because they did not do the jurisdictional prerequisite necessary for us to get here. So quite frankly, it doesn't, even if I did not even notify these in an answer, you would be obligated under the court if these are true, to dismiss this case, Your Honor, because they do not have the correct jurisdiction to be able to continue the claim, Your Honor.
Then why did you do it at all? Even if I was wrong, Your Honor, you still gotta throw it out. And this is why. I tell ya, he's just right under that bus every time. Oh man. Jeff, I would like to purchase a car. One with an engine, preferably.
Again, we have the right to answer the hearing. We don't have a lot of time with these clients, Your Honor. I'm doing the best I can to and the docket's been pretty extensive, as you can see. So I try to get the answers in as soon as possible, but just given the high volume of my practice, that's not always possible, Your Honor. And I do believe that the statute contemplated that, Your Honor.
Mr. Wagner, go ahead.
Thank you, Your Honor. If I would just respond again, the statute says at the time and place fixed for the hearing. So it does contemplate that there is a fixed date and time when a response and defenses are due. And the time and place fixed was the 25th of October, not 3 and 4 weeks later to continue to come up with new defenses just because of a continuance, especially when the continuance is simply requested by the tenant. So I don't believe it's accurate that they have, as long as the matter is continued, that they can just keep coming up with new defenses. Those needed to have been established by the 25th or at the latest by the 8th when it was continued to.
Yeah, and here's what I would say. I mean, I do think today is the date that the court has set for the show cause motion. Yes, the landlord set it for October 25th, but then the court, per our normal proceedings, set that over 2 weeks because the tenant obtained counsel at that time. Fortunately, on November 8th, due to a statewide court outage through no fault of any party, we were unable to do that hearing. So I set the court date for today. So today is the time and the place for the show cause hearing. I agree with Mr. Kiernan in that I think at any time, verbally or in writing, a tenant can raise jurisdictional issues. I have to find that this court has jurisdiction to hear this matter. So my options for you, Mr. Wagner, are whether you want to proceed orally today or whether you want additional time to respond to the amended defenses, essentially.
Thank you, Your Honor. We're prepared to proceed today.
Okay. And I did receive your response to the underlying motion to dismiss, and I assume you may supplement orally. So because it's couched in terms of a motion to dismiss, I'm going to hear that first and then go to the underlying show cause. So Mr. Kiernan, go ahead with especially the jurisdictional issues that you want me to decide before the underlying show cause.
There's no information in the record that they served the housing authority, which was required under their HAP contract, Your Honor. I'm not saying that that did not happen, but that is not in the file. So you are not able to effectuate service without that. They might have a document that says that they did that, but I have not seen it, so I cannot verify it. There's no documentation that shows that they gave the required VAWA notice. With that, again, I'm not saying that they did not do that, but that is not in the record, so you're not able to make that assumption. So they did not, again, those are two very large jurisdictional prerequisites that are federal law that the landlord needs to follow, Your Honor. So I think that those two just on their face make this a fatal flaw. They need to redo the notice. And they need to they need to issue the correct notices, Your Honor, or provide proof that they did provide those at the time of the notice. The law is pretty clear. They need to simultaneously, according to the HAP contract that they signed, they need to serve the housing authority. And again, that is not in the record. They need to attach the correct VAWA information. That is not in the record. So I believe that those two are fatal. And I do believe that the waiver argument, Your Honor, is fatal. If you look at all of the underlying incidents that occur in the notice, they all occur prior to the acceptance of rent in August. And if you look at Wilson v. Daniels, they essentially said, there's a quote from there that says, the landlord was accepting rent with one hand and writing the notice in the other hand. This is not okay. They have the obligation to not accept rent. Now, they can say that this is a continuing violation. So I think they would be able to have issued a new notice in September after they had accepted rent. But I believe that they have waived the ability to evict for any actions prior to August, which again is the only information which is in the notice. So, Your Honor, I believe that this complaint is fatal for pretty much 3 reasons before we even get to the factual matters, Your Honor.
Mr. Wagner, go ahead.
Thank you, Your Honor. First, my client is prepared to testify that the valid documents were issued with the notice to quit. My client's also prepared to testify that the housing authority did receive a copy of the notice to quit. There is nothing in the statutes that requires that the declaration or proof of service be filed with the lawsuit indicating that those documents were provided to the housing authority or the VAWA notice similarly. So the tenant or my client's testimony, testifying and attesting to the completion of those 2 requirements invalidate the defendant's motion to dismiss there. My client completely complied with the federal law. And then finally, As to the waiver issue, the statute, the notice is quite clear. It says, this is a serious and repeated violation of your lease agreement that has not been remedied and is directly affecting neighboring residents. Additionally, you have destroyed the fire and smoke alarm with the premises and have refused to allow access. So it was clear in the notice to quit that the problems were ongoing, were up until the date that the notice was issued on August 26th. The rent was issued or collected on August 6th. So the notice was quite clear that the problems had been continuing. No rent was collected after the notice to quit. So there is no waiver issue that's valid here. And finally, neither the defendant's motion to dismiss or amended motion to dismiss made any comment about all of these serious allegations, these serious safety allegations, the cutting of the fire alarm, the threats to neighbors. Apparently there's been additional incidents regarding a handgun and screaming, a physical assault.
And I would just object to these. They're not in the notice, Your Honor.
Well, yeah, so just hold on. I want to move back to the jurisdictional issue, though, before we get down the road of the underlying show cause. So it sounds like there's going to be testimony given about compliance with notice to the housing authority and the VAWA notice. Is that correct?
That's correct, Your Honor.
So let's go ahead and swear in Mr. Ramsey. Mr. Ramsey, can you raise your right hand? Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? You're going to have to say yes or no.
You must be muted.
Yeah, we don't. He's not muted, but we don't have audio. You might need to connect your audio down on the left-hand side of the screen with the microphone, the little arrow by it.
Is this working now?
There. Yep. All right. So Mr. Ramsey, let's have you state your name. There, I can hear you.
Okay.
Can you hear? Okay. Let's have you go ahead and raise your right hand again. Do you swear and affirm that I can't see your hand? Can you raise your right hand? Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead and state your full name.
Joshua David Ramsey.
Okay, Mr. Wagner, your witness.
Thank you, Mr. Ramsey. Your Honor, do you want me just to address the first two preliminary matters now or proceed into? Okay.
Well, you indicated in your offer of proof that he would testify that the housing authority and VAWA were given notice. So I'd just like some more information on that. And
Absolutely.
Just an indication into the record of who he is in relationship to the landlord.
Thank you. Mr. Ramsey, what is your occupation?
Property manager for Westgate Terrace Apartments.
And is Westgate Terrace where Ms. Chappelle resides?
Yes.
And how long have you been in that role?
2 years.
And what are your job responsibilities in that role?
Upholding or upkeep of the property and safety of the residents.
Are you familiar with Ms. Chappelle?
Yes.
Did you serve her a notice to quit?
Yes, I did.
When you served that notice to quit, did you also issue a copy of that notice to the housing authority?
Yes, I did. The Bremerton Housing Authority.
And how did you provide that notice? To the housing authority?
Mailed.
Okay. And when you issued the notice to quit to Ms. Chappelle, did you also issue her the VAWA materials?
I did. And I also issued her the VAWA form that she signed too.
Thank you.
What was the date that housing authority was notified?
August 26th is when I mailed it out.
And was that also the day that you served the notice to quit to Ms. Chappelle?
Yes.
Like, I'm going back to the complaint. And then what about the VAWA notice?
That was given with a notice to vacate. Or notice to quit.
Any other questions, Mr. Wagner?
No, Your Honor.
Mr. Kiernan?
Do you have any contemporaneous documents that show that you made those that you mailed to the housing authority?
Objection to relevance. There's no requirements for contemporaneous proof.
Well,
I'm just trying to
hold on. Let me rule on this objection. the burden of proof is on the landlord here on an underlying show cause. And so it is a very valid question if there are documents to support what is being said. So go ahead, Mr. Kiernan, I am going to allow it.
Do you have any proof that you sent this contemporaneously to the housing authority?
The proof would be, we would call the Bremerton Housing Authority and ask for the notice that I sent them, the same that I gave to Ms. Chappelle.
Okay, but that is not in the record, and there's nothing that you have that can show that you sent that on the correct date.
I have it in her file with her notice that I gave her.
Okay. And do you have any proof that states that you accompanied the VAWA notice with the actual rent? Because it's not included in the notice that is in the file in the complaint.
Again, the proof would be with the notice that we sent to the Bremerton Housing Authority. So we would have to contact the Bremerton Housing Authority to get that proof.
Because, yeah, I guess I would be confused why the notice would be in the file, but it would not include the VAWA notice that went with it, despite the fact that the lease agreement clearly states that a VAWA notice is necessary. So you don't have a reason why it wouldn't have been included in there?
No, it was included in there.
But again, there's no proof and it's not attached to the notice in the complaint.
Objection asked and answered.
Okay. I have no further questions about this just jurisdictional matter, Your Honor. Again, it sounds like they might have proof and they can furnish this, but at this point they have not carried their burden of being able to prove this.
So Mr. Ramsey, the notice to housing authority and the VAWA notice are those documents that you keep?
Yeah.
Okay. Is that something you can provide to your attorney to provide to the court?
Yeah.
Okay. I am going to require that I do. So here's my ruling on this as far as the motion to dismiss. I think at this point, if I was just to go on testimony, we have one party saying they did it. And we have another party saying it's not in the file, so we don't know if it was done. To me, that's 50-50. I can't say whether it's true or not. I would like to have the landlord submit those two documents to the court via their attorney. So specifically the notice to the housing authority and VAWA notice. And I will state explicitly, this court has on a number of occasions consistently ruled that those are jurisdictional requirements where someone is on a Section 8 housing choice voucher. So before I proceed further, that does need to be satisfied.
Your Honor, if I may raise one more point here.
Go ahead.
So the case law is clear that a proof of service is adequate proof. I would think that Mr. Ramsey's testimony would suffice as a proof of service.
No, because he's a party to the case. So how can his testimony is not proof of service that these things were done. I am asking for and ordering that before I make a ruling on the jurisdictional issue, that those documents be provided to the court.
Okay, so just to clarify then, the notice that was issued, or that was given to the notice to quit is the same notice that is in the file. You just want a proof of service indicating that that was given to the housing authority? That's what I'm familiar with.
So what I'm telling you is that the complaint and summons that got filed with the court does not show that it was served on housing authority and does not show the VAWA notice. Typically, I will tell you that when I receive UD cases under Section 8 housing choice, that the complaint actually attaches those, as Mr. Kiernan said, contemporaneous documents showing those two jurisdictional items have been met. So I am asking for that evidence.
I appreciate, Your Honor, the clarification. I'm familiar with the eastern side of the state where we would traditionally, attach the VAWA documents in the complaint, and then we would provide a proof of service that the plaintiff would fill out indicating they provided to the housing authority and the VAWA documents.
And I don't have that even in this case. So if that's what you want, here's the thing. I'm telling you what I want to see. You provide me what you think is sufficient to prove that, but I'm telling you, I don't think just on testimony alone that yes, it was done when the tenant is saying, I don't think it was done. I don't think it's sufficient to meet the burden of proof. So either we can get some documents, or if you want to provide whatever you would normally provide. But I'm telling you, typically here in this court, I do have the actual VAWA notice that comes with the complaint so that I can assure myself that that jurisdictional hurdle for Section 8 housing vouchers is satisfied. Okay, so what I'm going to do, I'm going to reserve ruling on the motion to dismiss to allow additional time for filing to December 6th at 9 a.m. I would set this over a week. Unfortunately, we can't because of the holiday next week. So the next docket we have is December 6th at 9 a.m. I will also, depending on my ruling on the motion to dismiss, if I deny the motion to dismiss, then we'll move on to the show cause hearing at that time. I would say other than briefing on, because this was raised earlier, other than additional documents I've requested, there'll be no new filings allowed between now and December 6th.
All right. Thank you, Your Honor.
So
Okay.
just to clarify, Your Honor, we're
Yes.
continuing this to December 6th, and in that time, we'll provide you a declaration with the proof of service.
Correct. Okay. All right. Thank you both. We'll see you back December 6th. You are free to log out. Okay. And then number 8, 242-010-1508 Cornerstone Residential Westgate Terrace Apartments LLCs versus Christina Chappelle, Mr. Kiernan.
Yes, and before we get to anything on this, I would like to correct the record. I received some information yesterday that states that Miss Chappell does not have a housing choice voucher through Hoswell. I don't know if she has it through someone else, but I think I can say pretty definitively she does not know where her subsidy's from. But I wanted to correct that as soon as I got that information.
That she does not have a housing voucher.
Housing choice voucher, at least through Hoswell, Your Honor. She told me that she thought she did, but I think she made a good faith mistake given the fact that she's been working with Hoswell on another matter.
So I know we had started this hearing, and I had asked for some additional information about the notices. So where are we at?
Good morning, Your Honor.
Yeah.
Yes, so we filed a declaration, an amended proof of service that showed that my client provided Ms. Chappelle the VAWA documents, and also that my client provided the VAWA documents and the copy of the notice to evict to the Bremerton Housing Authority. It looks like yesterday, Mr. Kiernan filed a declaration of Christina Chappelle, even though you had indicated the only thing to be filed was this declaration from my client. Nonetheless, Ms. Chappelle indicates that she has a subsidy and then makes a comment that she doesn't have a voucher through Bremerton Housing Authority, and that's only half right. She does not have a tenant voucher. That part is correct. But as Mr. Kiernan indicated, she does not know where her subsidy comes from. It does come from the Bremerton Housing Authority. My client's property is not voucher-based. It's a project-based voucher. And that money is distributed through the Bremerton Housing Authority. So Mr. Kiernan's attempt 2 weeks ago to raise an issue with VAWA has no grounds. His attempt to raise an issue with notice to the Housing Authority also has no grounds. I also just wanted to add to that, just for the record, service of those documents is not a predicate notice to a jurisdictional condition, as he argued in his briefing. Those are federal statutes, but they do not affect the unlawful detainer. They're not predicate notices. Predicate notices are like the pair vacate or the complier vacate. The others are not predicate notices. And just to support that, both of the cases that opposing counsel cites, Sowers v. Lewis and Sullivan v. Purvis, both of those refer to pair vacate notices or an incorrect complier vacate. Neither of them refer to providing the Housing Authority documentation. I just wanted to clear that for the record, just so the court has that knowledge that that the landlord does not have to prove as an affirmative part of its case that they provided these documents. Nonetheless, we have shown that to the court. So I think this part of the argument can be moved on from. Thank you.
Okay. Thank you. Mr. Kiernan.
Well, I would like to say that those state that any that you need to follow the statutory procedure, and if you look at the lease provisions, it does say that they need to follow the state and local rules as well. So and those state and local rules say that you need to include every information that is required in the lease. I would like to just note one of the big problems that we had with this is we didn't really know what the correct subsidy was, quite frankly, until just now, potentially. All I have is an email from Bremerton Housing Authority, which says that she's not a client and never has been a client. Now, it looks like they might have emailed someone at CMS. Now, it seems like the voucher might have been through CMS, but I don't know that that was the correct person. I don't know that that was anything. The only information that I have in the record is that Bremerton Housing Authority doesn't know who Christina Chappelle is, and has never had anything. Now, it was later emailed to somebody else, but I would note that email service is not correct. I have no way of knowing if that person is correct. I just don't know if that service is correct. The landlord, served the housing authority. They clearly knew that they had to, but they just did not serve the correct person, and there's no way of knowing that. Moving on from service, though, I really do think that the real compelling argument here is the waiver. They took the rent in August with full knowledge of it. I think there's too many just mistakes that occurred here that they just simply need to issue a new notice. They are bringing in a whole bunch of other things that happened after they accepted rent. I don't believe they can do that. I think they just need to issue another notice. It's going to be a lot cleaner, Your Honor. And again, if you don't think that any of my procedural matters are sufficient, which again, I believe that it's the waiver argument really is undisputed here. The fact of the matter is they took rent with full knowledge of the breach. And if you read Wilson v. Daniels, it says that, and now this could be a continuing breach, so there's nothing stopping them from issuing another notice for these breaches, but they accepted rent with the full knowledge of the breach. And Your Honor, if you feel like these procedural matters are enough, my client is going to be here to testify to the merits as well, Your Honor.
Your Honor.
Hold on one second. I'll come to the waiver in just a minute, but I'm going to address a couple things with the jurisdictional and notice issues. So first of all, once defense raises procedural jurisdictional issues such as proper notices weren't filed, then it absolutely is up to the court to inquire of those. I find, though, that those notices in these amended declarations were served. So I'm taking that issue off the table. I think the landlord has complied with the requisite notices, both federally and under state law, to proceed forward. So that does leave us with the acceptance of rent waiver argument. Mr. Wagner, go ahead on that issue.
Thank you, Your Honor. If I may read just from Wilson v. Daniels, just the one of the many relevant paragraphs. This is from, again, Wilson v. Daniels. Having in mind that these statutes are strictly construed and that they are designed to hasten the recovery of possession, we are of the opinion that when a landlord accepts the rent with knowledge of prior breaches, thereby waiving his right to declare a forfeiture of the lease because of such prior breaches, he also waives his right to rely on such prior breaches as a basis for setting in motion his statutory remedy of unlawful detainer. He must wait until the old breaches continue or new ones occur. And so looking at the facts here, the notice to quit does list multiple events up through July 31st. The landlord did accept rent on August 6th. But what opposing counsel is ignoring, as he ignored in his second answer in defenses and is ignoring again now, is that the notice to quit that was then issued on August 26th concluded by saying, property staff has repeatedly requested that you cease smoking within your unit. You have acknowledged that you smoke within your unit on multiple occasions. This is a serious and repeated violation of your lease agreement that has not been remedied. So it's clear that it has continued. It's going on past the August 6th acceptance of rent. Now, if I may continue, that has not been remedied and is directly affecting neighboring residents. Additionally, you have destroyed the fire smoke alarm within the premises and have refused to allow access to your unit to fix this issue, thereby causing a serious safety fire hazard. So the landlord clearly indicated in that notice to quit that there are two continuing violations that have continued since the August 6th acceptance of rent. So there is no waiver. The landlord entirely complied with the requirements of Wilson v. Daniels. The tenant.
So she smokes in her apartment and destroyed the smoke detectors. She's going to testify. This will be good. I promise.
Continued the breaches after the acceptance of rent, and the landlord called her out on those breaches correctly in the notice to quit. The landlord said, "You are continuing to smoke, and you have continued to refuse to allow access to allow us to fix the smoke alarm." So there is no waiver here. And then I can go on, or if you want to address this point first,
Are you moving on from the waiver issue, you mean, or just additional?
Yes, I mean, I can go on about the waiver issue. I think that's pretty conclusive. As I indicated in my plaintiff's response, this tenant has not only continued those breaches that are mentioned in the August 26th notice to quit about continuing to smoke, continuing to refuse access. The tenant has unfortunately continued the behavior, as I indicated, for several pages worth of disturbances. I believe she's been cited by law enforcement. She's threatened neighbors. The conduct is ongoing and very concerning. And just to conclude that, while I appreciate opposing counsel's attempt to raise procedural issues, neither of the answers that were provided did anything other than deny any of the actual substantive allegations. And it's clear from case law that a party may not rely on mere allegations, denials, opinions, or conclusory statements. And this is citing International Ultimate Inc., the St. Paul Fire and Insurance. This is a Court of Appeals case from 2004. So really, there is no other defense that's been raised here. The tenant has indicated and acknowledged on multiple occasions what she's done, that she's continued smoking, that she's cut the smoke alarm. So there really is no valid defense here. So we're asking for the writ and a judgment today, Your Honor, for the safety of the community and peace and quiet enjoyment of all the neighbors of Miss Chappelle.
Thank you. Mr. Kiernan, go ahead.
Your Honor, I read the same exact provision that he stated, but I would say that this states that they need to issue a new notice after they've accepted rent. I'd ask you to note the dissent.
Issue a new notice.
Not after the acceptance of rent.
Yes, they did. They accepted rent on August 6th, and then they issued the notice on August 26th.
They waived.
I'll come back to you, Mr. Wagner, but I do note the date of the notice is August 26th. So I think that Mr. Kiernan, go ahead.
Yeah. So, but they accepted rent. All of, I would just like to read the dissent, which, states, which again, it's not dispositive law, but it kind of gives you an idea of what the holding is, which says that there's generally recognized exception to the rule that the acceptance of rent with the knowledge of a breach of a covenant is a waiver of the right of forfeiture with such breaches. The exception applies when breaches are continuing and covenants of the breaches are continuing. The majority recognizes this exception, but states that the lessor must wait until old breaches have continued beyond the time of acceptance of rent. Your Honor, they accepted rent for the month of August. Your Honor, they knew all the events. There's a holding in Wilson that basically says they were preparing the eviction notice with one hand and accepting rent in the other. They're just not allowed to do that, Your Honor. They accepted rent with full knowledge of the breaches. So they need to wait till the acceptance of the rent is over and issue a new notice, Your Honor. They certainly can issue all these in a new notice, but they need to wait till after they've accepted rent, Your Honor. They cannot accept, because Miss Chappelle had every reason to believe that all of the conduct prior to July would not be at issue because they accepted rent, Your Honor, and she had every reason to believe that. They use vague cursory allegations that suggest any events after July 1st, but that's not with any sort of specificity. They just said, you've been continuing your things. There's no dates, there's no time, there's no information enough for me to provide a defense, which is required in the subsidized housing, Your Honor. But again, I think that is largely irrelevant because I think they must wait for the old breaches to continue beyond the time of acceptance of rent, Your Honor. The acceptance of rent was until August, Your Honor.
If I may briefly respond, Your Honor.
I don't think I need it. I'm good. Thank you. So here's my ruling on the waiver issue. So rent was accepted August 6th. Let's say it was for the whole month of August. So be it. What happens on August 26th, as of August 26th, as I read the 30-day notice to quit and vacate, it is clear to me that the landlord is indicating historically what the complaints have been. And then specifically state with regard to the inspection notice with the fire alarm, it states you came into the on-site office after receiving this notice. Property staff asked if you were still smoking within your unit. You confirmed that you are smoking in your unit, attempted to excuse behavior, etc. Tenant became upset when told to stop. Then when you go to the second page, as of August 26th, which is very clearly after rent was paid, it states property staff has repeatedly requested that you cease smoking within your unit. You have acknowledged that you smoke within your unit on multiple occasions. You also have destroyed the fire and smoke alarm, which did occur before the 6th when rent was accepted, but as of August 26th was still refusing to allow access to the unit to fix this issue. So to me, this fits exactly within the holding of case law, which is historical violations continue to occur after August 6th when rent was accepted. So I am declining to find any waiver of this issue, and we will move forward on the underlying show cause. I think Mr. Wagner has been heard on the reasons for the underlying show cause and the underlying 30-day notice. So Mr. Kiernan, I'll give you a chance to address the underlying request for an order for writ.
All right. I have my client on and I'd like her to testify, Your Honor.
Okay. Ms. Chappelle, can you turn on your camera and unmute? And is it Chappell or Chappelle? I apologize.
It is Chappelle, Your Honor.
Chappelle, okay.
Yes.
So Ms. Chappelle, go ahead and raise your right hand.
Yes.
Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God. Yes, I do, Your Honor.
Okay, your witness, Mr. Kiernan.
All right. They are alleging one of the most material things that happened was that you destroyed the fire alarm in your unit. Could you please explain if did that occur? And
The cutting of the wires?
yes.
Yes, it did occur, and it was done by doing a test on my landlord.
And why did you do that?
Simply because I wanted to see if he was staying the night inside the building with all of us.
And why did you cut the smoke detector? Why did you think that was necessary?
Because I wanted to see how fast it would take him to get down to my front doorstep.
Okay. And is there a reason that you thought that the smoke detector would help us understand
3 o'clock in the morning. 3 o'clock in the morning.
Can you help us understand why you chose to do the fire alarm? Or cut the smoke alarm?
Because I wanted the police and the fire department to show up so I can talk to them.
What did you want to talk to them about?
I wanted to tell them that my landlord. I wanted everyone to see proof that my landlord was there at 3 o'clock in the morning when he should be home in bed with his wife and his family.
And why was that a big deal for you?
Because he is having an affair with one of our residents.
Objection relevance?
I'm sorry, but it is the truth.
Yeah. Hold on. Mr. Kiernan, do you expect more questions along this line?
Westgate Terrace 85.
Hold on, Miss Chappelle.
Yes, I do. And I unfortunately do need to have my client testify a fair amount. At this point, I'm moving towards, I think we need, if a stay is going to be issued, I'm going to be asking for an extensive amount of time because my client is having kind of severe mental health issues. So I'd like to get that on testimony, Your Honor.
If I may.
Go ahead.
If I understand the opposing counsel correctly, he agreeing perhaps to the writ and maybe requesting a stay. If I could consult with my client maybe briefly and see if they're agreeable to 30 days or something rather than
I think
prolong this testimony.
I understand, Mr. Wagner. And so Mr. Kiernan, is the thought here at this point, given
I want my client to feel like he's been heard, Your Honor.
I understand that, but we also are an hour and 40 minutes into a docket that's usually an hour. So out of judicial economy, I am asking if Mr. Kiernan, your client's position is at this point, we're in agreement with a writ and we are asking for a stay.
I do not believe that is the position of my client, Your Honor.
So then let's not hear testimony about a stay. Let's hear testimony about whether a writ should issue.
Okay. All right. Well, I would like to just address the underlying issues and just to get them on the thing. And again, I apologize, but
let's do this. We're an hour and 40 minutes into this again. Mr. Wagner, what I will do, let's take a brief recess. Mr. Wagner, you can talk to your client about.
Yeah, could you put me into a Zoom? I mean, maybe into a breakout room, Your Honor. I could certainly try and get there.
With you want with your client, you mean?
Yeah, with my client.
Okay. What we're gonna do, let's be in recess of 5-10 minutes. Whenever you guys pop back in, we'll get restarted. Mr. Wagner, do you want me to put you in a breakout room with Mr. Ramsey?
That would be great. Thank you, Your Honor.
And here's my hope, counsel, given my rulings on some of the underlying issues we were here on. Is there some agreement between the parties that maybe this is properly an agreement for writ with an agreed stay for a certain period of time? If not, I'm happy to move forward, but I think that's the conversation I would request.
Thank you.
I guess in the alternative, Mr. Wagner, if you would agree. Well, I never mind. I don't think let me try and get my client to agree to something, and then we'll get back to this. Okay.
When we come back, if the two of you need to have a breakout room to hash out some things, that's fine too. So let me create 2 breakout rooms. I'm going to try and do this correctly. Mr. Ramsey, my hope is to assign you and Mr. Wagner to one room. And then I'm going to try to create a new room for you, Mr. Kiernan and Ms. Chappelle. It's not giving me any option to create more than one room. Hold on, let me go into options. Yeah, why don't we just go off if you want to give her a call?
Yeah, I'll go off.
Okay.
And I'm going to leave the docket. And I think my assistant is there helping Ms. Chappelle. Could you log off this? And we'll both log on after a brief 5-minute phone call.
Sounds good. Okay.
Yes, we can do that.
And I will say I will attempt to make this as short as possible, but there are challenges that I'm dealing with, Your Honor.
Understood. So let's, Ms. Chappelle, your attorney's going to call you. We'll be in recess for 10 minutes.
Here, Your Honor.
Thank you.
Thank you.
Okay, thank you.
I think I'm ready. I would propose perhaps we issue the writ today and then maybe stay it for a week, and we can have a week to talk about a potential stay. And I do have approval from my client to do that. And maybe we could work something out in the meantime.
Sorry, just so I understand. Thank you. Immediate writ, and then talk.
We can talk next week about a stay. Maybe we can come to an agreement. Maybe not, but if not, we could have a contested hearing about the length of the stay.
I hear you. It sounds all right. I just don't want to have further contested hearings down the road.
I would say at this point there would be no more contestation about the merits of the case.
I hear you. Josh, does that sound reasonable to you? It sounds fairly reasonable to me. As long, Mr. Kiernan, just so I understand though, what kind of stay would you be potentially arguing for?
Well, I would say I usually don't have too much luck going anywhere past 30 days. But you know, given situations, I might try a little bit. Like I said, ultimately, yeah, that would probably be around what my request would be.
Okay.
But again, I don't have that, and there's a couple other moving pieces that are happening right now. But like I said, we'd be willing to concede at this point that a writ should issue.
Okay. Josh, does that sound reasonable to you?
My biggest concern is the safety of my residents.
Yeah.
It's my number one concern.
So we can add in the stay that if there's any sort of stay or any sort of, violence or things that happen, I think there's a chance that she is not going to be in the unit shortly, is what I would say. Hopefully moving to a higher level of care.
That sounds great.
He's trying so hard not to violate attorney-client privilege and those private conversations that they've had. But if Jeff is the one that convinced his client that she needs to go to assisted living or I'm sorry, assisted living, then I take back everything I've said. He's a miracle worker.
Are you okay with this proposal, Mr. Ramsey?
Yeah, so what are we, what vacate date are we talking?
So
yeah,
ahead.
we'll have the judge decide next week is what my proposal is directly to you. But like, if we cannot come to an agreement, but usually the judge does not extend them very far.
Okay,
So you're talking.
so 30 days plus.
Well, I could try and ask for
No.
60 days, but I doubt it'd be granted because I don't think that would be reasonable. So I'm going to ask for a reasonable date that I think will be granted.
What if we
you-
just, sorry.
Are you ready for me, or did you guys need more time?
If we could just talk for one more minute, Your Honor,
Yeah.
maybe we can hash this out.
Okay.
Yeah.
Let me, just so I'm staying as much out of this. I wonder if I can just put the 3 of you or 4 of you in, I can put you guys all in one breakout room. Let me do that.
Yeah, let's do that. I think it should only be a few minutes, if that, Your Honor.
Okay. Okay, so in number 1,
Commissioner Carmi, Your Honor?
okay, are you able to hear me?
Yes,
Yeah.
just to state, we have a proposal, opposing counsel thinks it's reasonable. He's kind of struggling to communicate with Ms. Chappelle, so he was
Okay.
going to make a telephone call now.
Okay.
Yeah, hopefully we'll just wait maybe a couple minutes for him to return.
Okay, sounds good.
Thank you.
All right, I'm back. And I think we can have an agreement for the 6th. She would just like to add a provision that Mr. Ramsey would not harass her if she does not harass the residents. She will also agree that she cannot harass the residents either. So just a mutual no one harassing each other provision, if that would be agreeable.
Mr. Ramsey, what's your response to that?
We stay clear of her, so I think that should be fine.
Okay, yeah, I think it'd just be
Thank
best
you.
for everyone if we try and have as little contact in that month as possible.
Okay, so folks, it sounds like we may have an agreement. Let me know what we are doing.
So,
Yeah. Oh, you can go here.
okay.
We're agreeing to a writ, given the you found that there's no procedural issues to this, not to be executed before January 6th.
Okay. So does someone want to send, since we have a little bit of time, if someone wants to prepare that and submit it to me, I will get that signed.
I will do that. And then, Your Honor, the only other question I think is just a judgment for attorney's fees, since we have had to come here on 3 or 4 occasions.
I would just like to say that my client is on a fixed income. She doesn't, she's judgment proof. I just think that, and we were providing procedural defenses in a public housing case, Your Honor. I don't think fees would be appropriate in this case, given the severe barriers that my client has, Your Honor.
Judgment proof. That's a very cool way of putting that. But yeah, you can't get blood from a turnip. You can't get judgments, monetary judgments from people on Social Security, disability, because it's government money. And she's already on low-income housing. How much do you really think you're going to get from her?
And
What is the amount of attorney fees requested?
if you allow me 30 seconds, I'll take a look and see what we have.
Yep, go ahead.
Well, since there has been multiple hearings and then multiple drafting days of the responses and the declarations, as well as just the filing of the lawsuit, the total amount that my client's been billed to this point, not counting today's hearing, is $5,164.25, since we've had, as I said, 3 or 4 hearing days, multiple hours each time, and multiple pages of briefing. So that's what we would be requesting.
Mr. Kiernan, go ahead.
Yeah, I would just say my client is judgment proof, Your Honor. So the only thing that this judgment is going to be doing is severely limiting her ability to find new housing. My client has severe mental health barriers. She's in public housing as it is. She doesn't need another barrier to not find housing, Your Honor. She has, again, severe mental health problems. Any additional barriers to finding housing is going to lead her being on the streets, and we do not want someone with this level of mental health on the street, Your Honor. So I just like you to make it as easy as possible for her to find new housing, especially as part of this agreement, Your Honor. Whereas this judgment against her is only going to make that significantly more difficult.
I don't think this wasn't a personal service case, I don't believe. I
Yeah,
believe this was mail.
I'll take a look, Your Honor, as well. I'm looking at the proof of service. It says serve Christina Chappelle personally. And this affidavit was filed.
Let me get back in there. That's interesting. Yeah, it's cited in as affidavit of posting, but it does state in the body of the declaration that it was served personally. Okay. What I am going to do, I understand the argument of both parties. I think it's probably really apparent defendant is judgment proof. I'm not sure how you get around that, but I will grant attorney fees in the amount of $1,500. I think some of Ms. Chappelle's statements to her lawyer kind of created some of the additional need for hearings with regarding to service of certain documents. So I do think that has increased the cost of an otherwise kind of routine eviction. So I'll grant attorney fees in the amount of $1,500.
Thank you, Your Honor.
Thank you.
Okay, and then what are we doing? So do you need a presentation date, or do you think you'll both be able to get the stay or the writ with the stay for 30 days done and submitted?
I couldn't imagine there's going to be too much dispute here, so I think we can
Agree.
probably get it done without a review date.
Okay, sounds good. We will make that note that parties are in agreement for a order for writ to issue not to be executed before January 6th, 2025.
Thank you, Your Honor, and thank you, counsel.
Thank you, Your Honor. Yeah.
Thank you. Thank you, Ms. Chappelle, for being here. Okay, we will go ahead and end docket.
Yeah, the attorney's fees were not for Jeff. Jeff is paid, he's paid from, the government, public assistance, because he's a public defender, I believe, or no, he works for a legal aid service. That's what it is. The attorney's fees are for the landlord's attorney. Yep, that's Ava, everybody's baby. But yeah, that case was so wildly interesting. All the intricate parts of it. For her to just blatantly admit, yeah, I cut the wires on the fire alarm. I wanted the cops to show up because he's cheating. What? What there, Miss Busybody? Yeah, it was crazy. I'm very glad that she's getting into assisted living, if that is truly the case. But I think the amount that landlord has to pay in attorney's fees is worth it to get her out of the property. Because if she's having fights with neighbors, if she's smoking in her room, if she's cutting wires and doing all that other stuff, she needs to go. And she needs to get the help she really needs. So, and like I said, I featured all of our babies in the video tonight. We had Ava, we had Billy, we had Earl, and Bandit at the beginning. Not Bandit. Esquire at the beginning. Bandit, since I don't have a digital representation of Bandit, she just made a personal appearance. And of course, then there's, Billy making his personal appearance like always. Thank you guys so much for coming out and hanging out with me tonight. These cats are going from window to window, so I have a feeling there's a stray out there or something. I'm going to go check it out. I love you guys all so much. You've been amazing. Be safe, be well, sleep sweet, and much love.